A very good afternoon to all my dearest student friends. Indeed, it gives me a great deal of pleasure when I go to deliberate on the consumer protection law. You see, the structure which I have made for deliberation in such a way that I will first touch upon the introduction part to the consumer protection law. Then I will speak on the evolution, how the consumer protection was evolved. Then I will touch upon the consumer authorities, who are they under the Act, and what is the process of complaint, and whenever there is a complaint, how to file a complaint, what are the powers the Central Consumer Protection Authority enjoys, the product liability, the e-commerce. Today we are more concerned so far as business transactions are there, and whatever orders, the enforcement of orders of forums, and if at all there are offences, what are the penalties which are there, and the consumer protection councils, how mediation do take place. All these things will be covered in my deliberation. So after hearing the deliberation, a student will be able to understand the evolution of consumer protection. Apart from that, they will also be able to identify the consumer authorities, who are they under the Act, and they can well elaborately discuss. The students will be able to discuss on the powers of the Central Consumer Protection Authority, and in addition to that, the students will be able to explain the process of filing of complaints, and they will appreciate the importance of various provisions of consumer protection e-commerce rules 2020. So now, to start, the befitting introduction would be that the economic growth of a country, in fact, depends on consumers. So it is vital that they trust the products. It is vital that they trust the services. That means they must trust the product and the service providers. So in 1930, when the United States of America was facing great recession, the then President Herbert Hoover, while addressing the Congress, had remarked that your economic depression cannot be cured by legislative action or executive pronouncement. Rather, economic wounds must be healed by the action of the cells of the economic body. So, when we are talking of the economic body, the producers and consumers themselves. We are talking of economy, that too in a free economy, the substandard products or the substandard services has to be sacrificed for producers or the providers of good quality goods or good quality services which have an overall impact on the economy. Because today, who is the king? Consumer is the king. What normally each company is looking for, that is consumer satisfaction and taking care of consumers' interest. That is in the long-term interest of businesses as a happy customer, because that would not only prefer purchasing the quality products or quality services for themselves repeatedly, but would also encourage prospective customers by giving good feedback and thus help in increasing the customer base of business. Secondly, the self-regulation in producing quality products may protect the producers from the government interventions or any kind of government actions which can impair and which can also tarnish the goodwill of the business firms. So consumer protection and empowerment attains prime importance, since all human beings, we are the consumers, some way consumers of goods. So all human beings are some way consumers of goods and services, availing services. And even businessmen who partake in selling of other goods and services are also ultimately consumers of goods and services which are produced by other sellers, which are produced by other service providers. So business protection and your consumer protection, they go hand in hand. And the consumer protection is an important for businessmen as for others because of long-term interest of business in consumer satisfaction. So with this kind of introduction, let me touch upon the evolution of consumer protection, how consumer protection was evolved. So the concept of consumer protection, I must tell you, is not new. We find several references of the law and policies of consumer protection that too in ancient Indian context, including during the Kautilya's Arthashastra. The modern consumer movement worldwide also initiated when US President John F. Kennedy on 15th March 1952 referred to four consumer rights in his famous speech in the US Congress. From the next year, 15th March was celebrated as Consumer Rights Day, World Consumer Rights Day, as the initiative of Consumer International, because an international consumer association formerly known as Consumer Union. It was a result of worldwide consumer movement that in the year 1985, the United Nations adopted the Consumer Protection Guidelines. And any of the mandates of these guidelines for the signatory countries was to pass consumer protection legislations in their respective countries. And India, being a signatory to the guidelines, became the forerunner to pass the Consumer Protection Act in 1986. So the very next day of adoption of the guidelines in 1985, in fact, India is perhaps the only country where a dedicated mechanism or the machinery for redressal of consumer complaints has been set up. So before passing of the Consumer Protection Act, way back in 1986, there were various other existing legislations to protect consumer interest, that too including Indian Contract Act, the Sale of Goods Act, the Standards and Weights and Measures Act, the Dangerous Drugs Act, the Agricultural Produce, your Grading and Marketing Act, Indian Standards Institutions, that is your Certification Mark Act, the Prevention of Food Adulteration Act, which do, I would say, some extent they protect the interest of the consumers. However, the need was felt that to pass the Consumer Protection Act in 1986, as the producers of availing remedy under the above law was very expensive, was very time consuming, and that too was full of complexities. So the Consumer Protection Act 1986 was enacted to provide for better protection of the consumer's interest and for making provision for establishment of consumer protection councils and other authorities for the settlement of consumer disputes. So this welfare legislation was, in fact, well received as a boon by Indian consumers, and the working of the consumer dispute redressal agencies has served the purpose to a considerable extent under the said act. So to provide a speedier remedy over ordinary civil courts, the 1986 Act included a fixed period of time for disposal of consumer disputes. However, it was found that the cases were rarely decided, and that too when it is a question of deciding rarely, uh, So the process in the consumer forums established under the Act was always intended to be summary in nature, which doesn't include any kind of intricacies as involved in the civil court and free of complexities of ordinary civil courts. So, however, these forums have ended up to become civil suits, full of complexities. When forums have started pressing for the volunteers evidence, pressing of voluminous evidence, and going for arguments primarily due to the presence of lawyers defending the companies, which force the consumers complaint to hire lawyers for this case. So in some cases, forums refer the parties to mediation under the provision of Indian Procedure Code is there 1908, and however such cases were very less, maybe in number. Besides, there were several shortcomings noticed. And these shortcomings noticed while administering the various provisions of the said Act. So, consumer markets for the goods and services have undergone drastic transformation. And drastic transformation it has undergone since the enactment of the Consumer Protection Act in 1986. And we are talking of modern marketplace. Modern marketplace contains a plethora of products and services. So the emergence of global supply chains, rise in international trade, and that too rapid development of e-commerce. All of these have led to new delivery system for goods and services, which have provided new options, which have provided new opportunities for the consumers. And equally, this has rendered consumers vulnerable to new forms of unfair trade and unethical business practices, or your misleading advertisements we come across. We come across telemarketing, your multi-level marketing, we come across direct selling, we come across e-commerce. All of them, they pose new challenges to consumer protections and requiring appropriate and swift executive interventions to prevent consumer detriment. So therefore, it became inevitable to amend the Act to address the myriads and constantly emerging the vulnerabilities of the consumer. So in view of the above discussions I made, it was deemed expedient to repeal the extant law and enact a new law, namely the Consumer Protection Act 2011, which was eventually notified on 20th July 2020. So the provision of the new Consumer Protection Act 2011 will have an impact of revolutionizing the Indian justice delivery systems in the consumer cases. So now let's discuss the provisions of the consumer legislations by focusing on the new features of Consumer Protection Act 2019. So the case laws under the Consumer Protection Act 1986, they are still applicable and they will be discussed wherever necessity is felt. The Consumer Protection Act 2019 is really a comprehensive and added various new features in comparison to the earlier regime, that is Consumer Protection Act 1986, as all the features cannot be analyzed in this unit. So only the main features are covered with special focus, with special attention um, to certain topics, and they are your consumer authorities under the Act. And whenever there is a complaint, consumer is to file, who can file a case, what is the definition of a consumer, and how does filing complaint online complaint they go. In addition to that, the mediation, because mediation under the Consumer Protection Act 2019 is important, e-commerce issues and challenges, your product liability, the Consumer Protection Act 2019, Central Consumer Protection Authority, offenses, penalties. Now coming to the consumer authorities under this act, as we all know that Consumer Protection Act 2019 provides four types of entities, authorities which are under Consumer Protection Council. This was also there in the old act. The Central Consumer Protection Authority, section 10 to 27, it is all dealing with the protection of the rights of commencement, whatever common consumers are there to deal with misleading advertisements and unfair trade practices. Third one is your consumer disputes, redressal commission, and in that case, when we are talking of the redressal, obviously mediation has to be there. So the fourth one is the mediation cell, section 74 to 81. So basically, it is a three-tiered system of consumer agencies because consumer disputes redressal commission is there. So in that case, for adjudication of consumer disputes, there are consumer authorities which are established at the district level, at the state level, and the apex at the center level. So these authorities or the forums, they provide an alternative remedy and have not taken away the jurisdiction of the civil courts. So the consumer forums have been vested with certain powers of a civil court for adjudication of disputes. So some cases, additional powers for ordering search and seizure have also been conferred. So the commission, after the commission have the powers of a judicial magistrate of first class for the trial of offences, offences of non-compliance of their orders, which may be extended to 3 years, and the above, whatever I discussed with you, the powers are vested with all the commission, irrespective of their hierarchy. The chart depicts different adjudication of consumer forums. So, if we look at the national level, your state commission 1 crore to 10 crore, your national, because that is the jurisdiction, national commission above 10 crores, and we have national commission original where you have to go for an appeal, and we have national commission original review, revision, appellate jurisdictions, and we have also district commission, that is your original and review records. Now coming to the district level, because just like your civil courts, the consumer agencies are told that they are all established in three levels. That is, one level is district level, another level is state level, and another level is your national level. So first tier is at district level, that is the consumer and the district consumers, rather to be more specific, and the state and the national level. So first tier is at district level. So district, you can say, consumer disputes redressal commission. There is one, I can say, DCDSC for every DCDSC means District Consumer Disputes Redressal Commission. So, means for every district, for every village, uh, maybe we have to see that the DCDRC consists of the presidents and at least two members. The members of uh, the number of members in the DCDRC, that means your district consumer dispute redressal commission, can go up to 10 members. And the president of the district consumer disputes redressal commission um, can be a person who is a district judge or has been a district judge or a person who is qualified to be a district judge. Whereas the members in the district consumer redressal commission, we have to find out one thing, that person who is qualified to be a district judge, whereas the member of the district consumer disputes redressal commission can be a person who is not less than 35 years of age and has a bachelor's degree and has 15 years of relevant experience, that means legal experience, and it must have at least one female, and the commission has two jurisdictions, original and review. And under the original jurisdiction, it has the pecuniary jurisdiction up to 1 crore, which means such complaints in which the amount paid for the goods and services is less than 1 crore can be filed before the DCDS. And these provisions is different from Act of 96, under which jurisdiction was relating. And when I look at the state level, obviously at the state level, we find the State Consumer Disputes Redressal Commission has been established, and for every state, this is for every state, and some states like Maharashtra, they have multiple benches in one state because the area is big. And the State Consumer Disputes Redressal Commission consists of one president who is not less than, and the composition of the commission is not less than 4 members. So the president of your State Consumer Disputes Redressal Commission can be a person who is of the rank a judge, judge in a high court, or has been a judge of a high court. Members can be persons, any person not less than 40 years of age and is of or has been a presiding officer of a court or tribunal, and only 50% members the legal profession, and the rest bachelor's degree and 20 years experience in the relevant field is must. And that is why the State Consumer Disputes Redressal Commission shall have at least one female member, and 4 types of adjudication is there, and original is there. Then if you are not happy, then you can go for an appellate. There can be also revision, and finally there will be review. So under original jurisdiction, it has the pecuniary jurisdiction between 1 crore to 10 crore, which means such complaints in which the amount paid for the goods and services is between 1 crore to 10 crores. Can be filed before your State Commission Dispute Redressal Commission. And now coming to the aspect that earlier the State Commission could entertain cases whose value was between 20 lakhs to 1 crore. But increasing jurisdiction is beneficial. It is beneficial for the consumers who have to travel to state capital or filing their documents, cases before the State Commission in cases more than 20 lakhs. So your State Consumer Disputes Redressal Commission has statutory jurisdiction over the territory of the whole. So all the cases may be filed before the State Commission, before pecuniary value of the goods and services. So when we talk about the national level, that is in fact, at the apex level, that is the National Consumer Disputes Redressal Commission. There is one National Consumer Disputes Redressal Commission in the country situated in the national capital, and national capital is New Delhi. So same thing will happen over here. That means the National Consumer Disputes Redressal Commission consists of one president, not less than 4 members. So president of National Consumer Disputes Redressal Commission, otherwise we call it in short as National Commission, can be a person who is a judge in the Supreme Court or who has been a judge of the Supreme Court, and it has been a Chief Justice of any High Court also do that, or was held the post of member of or judicial member for the period of 3 years, and his experience of 25 years has to be there in relevant field. And the members can be any person who are or have been a judge in the High Court or has been district judge or additional district judge for a period of 10 years and a bachelor's degree, 25 years of experience in the relevant field. So just like your state commission and national commission, the national commission has also 4 types of adjudication. One is original, another is appellate, another is revision, another is review. So under the original jurisdiction, it has pecuniary jurisdiction over complaints in which the minor paid for the goods and services. That is more than 10 crores. So the pecuniary jurisdiction of the National Commission has been increased, which was earlier 1 crore. So increasing adjudication would reduce the pressure on National Commission, as most cases would be filed before your, or you can say, district level or the state level. So at the district level, as you can say, state level, but one has to take up the matter at the appropriate level depending upon the amount paid for the goods and services. So in this forum, it is also there a system. It is a system of appeals. Supreme Court, you can first file appeal for National Commission, and because when you are talking of the National Commission, which has the administrative control over all the state commission under the Act of 2019, the second appeal of substantial questions of law may be also be filed before National Commission, which is the first appeal heard by State Commission. So there is a system of appeal, Supreme Court, in case of that, first appeal from National Commission, which has to be filed within 30 days from the date of the order. But in case of National Commission, the first appeal from the State Commission within 30 days from the date of order, and the second appeal from the State Commission from any order passed in appeal by the State Commission, or only on substantial question of law within 30 days from the date of order. And after that, the State Commission will come. There you will have first appeal from which will come from the District Commission, and it must come within 30 days from the date of the order. So whenever there is a complaint, there is a process, definite process of complaint. Section 2 of 5 of 2019 Act defines complainant. Complainant is maybe a consumer, maybe any voluntary consumer association, but the association registered under any law for the time being in force. And the third is the central government or any state governments, the Central Protection Authority, or one or more consumers, where there are numerous consumers and they are all having the same interest, or in case of a death of a consumer, then we look for who is the legal heir or the legal representative of the consumer. But in case of a consumer being a minor, then we look for his parents or who is his legal guardian. Because consumer is also defined in a specific manner, because consumer means any person who buys any goods or any person who hires services for some kind of consideration, and includes any user of such goods or any user of any kind of with the approval of the buyer. But if the goods are bought or service are hired for the purpose of resale or any other commercial purpose, the case falls outside the act, because it has also been made very clear that if a person uh, use the good and when using the goods purchased exclusively for the purpose of earning his livelihood, and in fact by means this is by means of self-employment, he is still a consumer and may avail the remedy under the act. So the new act also includes your online transactions through electronic means or by tele shopping, or you may go for direct selling or multi-level marketing under it. And the section 2 of 6 contains the definition of complaint, which means you are making some kind of allegation, and those allegation writing made by a complainant for obtaining any kind of relief which is provided by or under this act. So an unfair act, or you can say the unfair contract or unfair trade practice, or you can talk about restrictive trade practice, has been adopted by any, you can say, um, any trader, or he could be a service provider, or the goods purchased, bought by him, or agreed to be bought by him, uh, unfortunately suffer from one or more defects, or the services hired, or the services availed of a or agreed to be hired or availed by the same, you can by him, the sufferer from any deficiency. So when we go for uh, the claim for product liability, action lies against the product manufacturer. So product seller or the product service provider, as the case may be, as noted above, the unfair contract has also been included here. So in the complaint, whenever we go for a complaint, we have to file the complaint. So how does filing of complaint they do take place? Complaint containing the relevant facts with some kind of supporting documents need to be filed before the commission of the competent jurisdiction in writing. So the new 2012 Act provides for long online complaints, and complaints can be filed online also. So the system of online complaint is being streamlined throughout the country. And however, currently not all commissions have this option. There is a free um, prescribed for filing complaints under rules, but there is no fee payable if the value of the goods and services paid as consideration amount is less than rupee 5 lakhs. So what are the procedures which are to be followed at the time of or after the complaint? There must be written complaint filed by the, and this complainant, when we are talking of along with relevant evidences which have to be there, like receipts. So after filing the complaint, there is an admission hearing, and if admitted, the notice is directed to be issued to the opposite party. If the admissibility of the complaint not decided within 21 days, the complaint will be deemed to be adopted, and the opposite party needs to file its reply within 45 days, and the said 45 days cannot be extended by the commission. So the reply is then followed by the rejoinder and evidence. So therefore, thereafter, final arguments are hard, and if they felt, if it is if felt necessary, the commission also can seek an expert opinion. There is no doubt about it. The matter, and even testing of goods can be ordered by the commission. But having said that, there are limitations for filing complaints because the period within which the complaint is required to be filed. Before the commission is 2 years from the date on which the cause of action has arisen. But however, a complaint may be entertained after the said period if the complainant satisfies the commission that he had sufficient cause for not filing the complaint, that too within such period, and if such a complaint is entertained by the commission, the reasons for condoning such delay need to be recorded. And there are certain reliefs which can be granted, and there can also be execution of orders. The relief can be passed by the consumer forums, like such as removal of defects or deficiencies in the services, like replacement of the goods, like refund of the price paid, like award of compensation for the loss suffered or injury suffered, may also award punitive damages, like discontinue and not to repeat unfair trade practices or any kind of restrictive trade practices, like your withdraw hazardous goods from being offered for sale, such as to seize manufacture of hazardous goods and desist from offering services which are hazardous in nature, and if the loss or the injury has been suffered by a large number of consumers who are not identifiable, but conveniently to pay such sums, but it cannot be less than 5% the value of such defective goods or services provided, which shall be determined by the forum, and the issue corrective advertisement to rationalize or to neutralize the effect of any kind of misleading advertisement, like seize or desist from issuing any misleading advertisement or to provide adequate cost to the parties. So these are some of the reliefs which can be passed by the consumer forums. So as told you earlier, some new types of order may be passed by consumer for under the 2019 Act, which will improve the effectiveness of the Act, particularly in the area of misleading advertisements or in the order against erring company, or you can say individuals to issue some kind of corrective advertisements in case of misleading advertisements, so as to neutralize the effect at their cost. And he will say that the cost, whatever we are talking of, will prove the effectiveness to curb the menace of misleading advertisements. Now, coming to the powers of the Central Consumer Protection Authority, the landmark feature of 2019 Act is the provision for establishment of a new authority. What is the name of that new authority? That is your Central Consumer Protection Authority. Why the authority is formed? That is for protecting the rights of consumers, promoting the rights of consumers, enforcing the right of consumer. And when I am talking of consumers, so that is as a national or as a class for regulating all matters relating to the violation of rights of consumers, matter pertaining to consumers, unfair trade practices, false and misleading advertisements, which are all prejudicial to the interest of the public. So the government or the authority, you can say, has been established way back in 2020 with its office in the capital of India, and it has started its activities of consumer welfare, if at all they are tossed upon. And for the purpose of filing any complaint, consumers can directly approach the central authority or any of its appointed officers for this purpose. Complaint can also be filed before the district magistrate, and the Central Consumer Protection Authority has the power to inquire the cause and inquiry to be made into a matter of violation of consumer rights, to be made into a matter of violation of or matter of violation of consumer rights or matter of unfair trade practices. So moto on receiving a complaint and that were being asked by the central government, it can also file complaints before appropriate forms to enforce the rights of consumers. And in a matter relating to, uh, you can say, rights, consumer rights, and the Central Consumer Protection Authority, uh, both when we look at they talk something and they always speak for so moto on receiving any kind of complaint or being asked by the central government. It can file complaints before appropriate forms. The purpose is to enforce rights of consumers. So Central Consumer Protection Authority is very much listed under the Act as a complainant. So in those matters relating to consumer rights, the Central Consumer Protection Authority can intervene in any impending or any pending cases before any forums or to review the prevailing safeguards and recommending any kind of changes as deemed fit. So the authority can recommend to the government the adoption of international covenants to protect the rights of consumers. So we have, you can say, Central Consumer Protection Authority has also mandate to promote research into consumer rights and raise awareness about the consumer rights at the ground level. And it can also team up with NGOs and encourage them also to work. And during the course of investigation, the investigator has the power of search, has the power of seizure under the Act. So normally provisions which are followed for search and seizure as given the Code of Criminal Procedure 1973. And after this investigation, the Central Consumer Protection Authority can order recalling of goods and withdrawal of services and reimbursement of the cost of goods and services and discontinuation of unfair trade practices. But in case of misleading advertisements, this can also order for any kind of advertisement to be withdrawn, to be modified. So it can also impose penalty on the advertisers, which may extend up to 10 lakhs or up to 50 lakhs, as it is. You can say the penalty, the penalty. It can also impose the penalty on the advertisers, which may extend up to 10 lakhs or up to 50 lakhs, as the case of repeat contraventions. So this penalty can also be issued on endorsers such as celebrities, provided they did not do due diligence before endorsing the product. So today, the central government and the state government have been conferred with the power to make rules under the Act, whereas the National Commission, the Central Commission can make a regulation under the 2019 Act. Order passed by central authority may be also be challenged before the sale of before the any kind of challenge being faced or appeal to be made to the National Commission. It has to be made within the period of 30 days from the date of receipt of such order. Now coming to the product liability, the Act when we are talking of And the Act of 2019 provides a new provision of product liability, which will be applicable to all cases where harm has been caused due to a defective product. So the Act defines harm as including personal injury, including your mental agony, including your emotional distress occurring as a result of a personal injury. So, under this provision, a complainant can bring an action for product liability against a manufacturer, a product or service provider, or a product seller. So, a manufacturer can be made liable if the product has a manufacturing defect or when the product is defective in design. So manufacturers will also be liable if there is a deviation from manufacturing specifications or when they do not conform to the warranty or if the product does not contain proper instructions for correct use to prevent harm. It is all clarified under the Act that liability is not contingent on the presence of fault on the part of the manufacturer. So what I mean to say that the product service provider is liable in case of imperfect, in case of deficient, in case of inadequate service, in case of negligence, or in case of conscious withholding of information that caused harm, and not issuing adequate warnings, not issuing because of non-conformity with warranty. The product sellers will also be liable if they had substantial control over the redesign, substantial control over the testing, substantial control over the manufacturing or even packaging or labeling of the product. They alter or they modify the product, and this was a substantial factor in causing the harm. So the seller has made an express warranty for the product, and the identity of product manufacturer is not known. They are not within the jurisdiction of India. They did not properly assemble or inspect or maintain the product. They did not pass on information about the correct use of the product from the manufacturer to the consumer. So the product liability provision also provides exception from liability to product seller in case of product was misused, in case of product was altered, or even in case of product was modified by the consumer. Now coming to the e-commerce, the new consumer protection regime under 2019 Act covers all modes of transactions, offline, online, through electronic means, tele-shopping, direct selling, or your multi-level marketing. So to regulate the e-commerce sector in India and protect the consumers from any kind of unfair trade practices in e-commerce, Consumer Protection E-commerce Rules 2020 were passed, which came into effect from 23rd July 2020. So these rules put a lot of duties on e-commerce entities in the interest of the consumers. So if you look at the applicability of the rules, the Consumer Protection E-commerce Rules 2020 are applicable to all goods and services bought or sold over digital or electronic network, including digital products, and applicable to all models of e-commerce, including your marketplace and your inventory models of e-commerce, applicable to all e-commerce retail, including multi-channel single brand retailers and single brand retailers in single formats or multiple formats, applicable to all forms of unfair trade practices across all models of e-commerce. Having said that, however, these rules shall not apply to any sort of activity of a natural person carried out in his personal capacity, not being part of any professional activity, not being part of any commercial activity which are undertaken on a regular basis, on a systematic basis as provided under the Act. These rules shall apply to multinational e-commerce entity offering goods, multinational e-commerce entity offering services to consumers in India. And as far as duties are concerned, some of the duties of e-commerce entities are that the e-commerce entity be a company incorporated. The Companies Act 1956 modified amendments as per the Companies Act 2013, or foreign company covered under 42 of Section 2 of the Companies Act 2013, or any kind of office or branch or agency outside India, but that is owned and controlled by a person who happens to be a resident in India, as provided in subclause 3 of clause 5 of section 2 of the Foreign Exchange Management Act 1999, needs to appoint a nodal person of contact or an alternate senior designated functionary who is resident in India. That is to only ensure compliance with the provisions of the Act or the rules made thereunder. Similarly, e-commerce activities shall establish an adequate grievance redressal mechanism having regard to the number of grievances and originally received by such entity from India, and shall appoint a grievance officer for consumer grievance redressal and shall display the name, contact details and designation of such officer on its platform. So any e-commerce activity shall ensure that the grievance officer referred to in Subrule 4 acknowledges the receipt of any consumer complaint within 48 hours and redresses the complaint within 1 month from the date of receipt of the complaint. No e-commerce entity shall impose cancellation charges on consumers cancelling after confirming, or purchases unless similar charges are also borne by the e-commerce entity if they cancel the purchase order unilaterally for any reasons thereof. And even if every e-commerce entity shall affect all payments towards accepted refund request of the consumers as prescribed by the Reserve Bank of India or any other competent authority or any under any law for the time being in force, or within a reasonable period of time as prescribed under the applicable laws. So, if we look at the liabilities of the marketplace e-commerce entity, obviously the marketplace e-commerce entity which seeks to avail the exemption from liability under section 1 of section 79 of the Information Technology Act 2000 shall comply with subsection 2 and 3 of that section, including the provisions of the Information Technology Intermediary Guidelines Rules 2011. So every marketplace e-commerce entity shall require sellers through an undertaking to ensure that the description or ensure that the images or ensure that other content pertaining to goods, pertaining to services on their platform. Maybe the platform is accurate and corresponds directly with the appearance, directly to the nature, directly to the quality, directly to the purpose, and other general features of such good or service. And in that case, one has to look at the duties of sellers on the marketplace, because there are certain duties of sellers in the marketplace as mentioned normally under the e-commerce consumer protection rules 2020. No seller offering goods or services to marketplace e-commerce entities shall adopt any unfair trade practice, whether in the course of the offer on the e-commerce entity platform or otherwise. No such sellers shall falsely represent itself as a consumer or post reviews about goods or services or misrepresent the quality or the features of any goods or services. Similarly, no seller offering goods or services through a marketplace e-commerce entity shall refuse to take back goods or withdraw or discontinue services purchased or agreed to be purchased, or refuse to refund consideration paid if such goods or service are defective, deficient or spurious, or if the goods or service are not of the characteristics or the features as was advertised or as agreed to. or if such goods or services are delivered late from the stated delivery schedule. So all these things will come into picture in a case. Similarly, there will be duties and liabilities of inventory e-commerce entities because if we look at the duties and liabilities of inventory e-commerce entities, every inventory e-commerce entity shall provide certain information in a very clear and accessible manner or displayed prominently to its users. Information like accurate information related to return, refund or exchange or warranty or guarantee, or information relating to delivery, shipment, cost of return, shipping, mode of payments, grievance redressal mechanisms, and any other similar information which may be required by consumers to make informed decisions. Information relating to, you can say, all mandatory notices, information required by applicable laws, or no, because no inventory e-commerce entity shall falsely represent itself as a consumer and post reviews about goods and services or misrepresent the quality or the features of any kind of goods or services. And any inventory e-commerce entity which explicitly or implicitly vouches for the authenticity of the goods or services sold by it, or guarantees that such goods and services are authentic, obviously shall bear appropriate liability in any action related to authenticity of such goods or services. And if there is contravention of e-commerce rules, the provision of the Consumer Protection Act 2019 shall apply for any violation provision of the. So therefore, punishment and fines are provided under the Act for non-compliance of the orders of consumer forums, are also applicable to any violation of the provisions of this Act. And there has been amendment to the rules, no doubt about it. The government is taking initiative also to amend the 2020 rules to bring transparency in the e-commerce platforms, further strengthen the regulatory regime to curb the prevalent unfair trade practices. Therefore, the draft of proposed amendment to the rules was put for public comments in July 2021, and prohibition of fraudulent flash sales and mis-selling or appointment of chief compliance officer, grievance redressal officers are inter alia the key amendments proposed to the Consumer Protection E-commerce Rules 2020. Now coming to the enforcement of orders of forums. So after the completion of the proceedings, the successful party can apply for enforcement of the order if the party against whom the order is passed does not comply. Every order shall be enforced by it in the same manner as if it were a decree made by a court in a suit before it. It means that unlike the previous act, the 2019 act gives the consumer forums the power to enforce their own orders. Earlier, the parties had to file application to district collector for execution purpose, but this provision would be really useful as under the previous law for non-compliance of order of the commission may impose punishment on the defaulting party in the form of imprisonment for from 1 month to 3 years, or a fine of 25,000 to 1 lakh, or both. But for exercising this function, the Commission have been given the power of judicial magistrate first class. So an opportunity of being heard will be given to the party being taking any kind of action under the above provision. So there is a provision for imprisonment and fine for non-compliance of order, which will be there. Now coming to the offences and the penalties, obviously unlike the Act of 1986 and the Act of 2019 provides new provisions relating to offences, there is punishment prescribed for non-compliance of order, for false advertisement, misleading advertisement, for manufacturing or storing or selling or distributing or importing of adulterated products, an imprisonment for a term up to 6 months or a fine up to 20 lakhs rupees, or both may be imposed for non-compliance of the order of the uh, order, or the misleading advertisement, the imprisonment up to 2 years, and the fine can go up to 10 lakhs of rupees, uh, depending upon the nature or the gravity of the case. So we have consumer protection councils. The old provisions of the consumer protection council of the center, national level, the state level, district level has been kept as it is under the Act of 2019. And now the minister in charge of consumer affairs in the center is the chairman of the center, that is Central Consumer Protection Council, and it has other official or non-official members. Similarly, the State Consumer Protection Council is headed by minister in charge of consumer protection in the state level. Similarly, the District Consumer Protection Council is headed by the collector of the respective district. And these councils are advisory in nature, and their object is to protect the rights of the consumers under the Act. Also, the mediation process is there. That is a landmark feature of the Consumer Protection Act 2019. The provision of mediation for resolution of the consumer cases. The cases where there is existence of elements of settlement, there may be acceptable to both the parties, may be referred to mediation. So at every commission, a mediation cell will be established and trained mediators will be empaneled by the commission. Because mediation is a process where the parties to a dispute voluntarily they try to settle their disputes amicably. It is a consensual process where the party can exit anytime they want. The process of mediation is a closed process, is a totally confidential in nature. And here, the mediator only plays the role of a facilitator, and the parties are the actual decision makers. They control the whole process, unlike the courts. If unsatisfied with the process, the parties may withdraw any time from the process and prefer to move to the court. Unlike in the court system where you once started cannot easily back out. Besides, in the process of mediation as a mediator, you are more closely in conversation directly to the parties and thus in a better position to understand their concerns, provide solutions accordingly. Unlike the courts, mediation believes that the parties themselves have the capacity to solve their problems. So with this, we come to an end of our today's discussion. Thank you very much. Have a nice time. Good day.